So good morning, everybody, and thanks again for coming back for another edition of our land classification working group. I believe everybody has a copy of the agenda. Is there anybody that doesn't? Everybody has a copy of their agenda. I'll just start off. I'm first up with a little recap of our last meeting. So Robin graciously put that together for me because it's been way better than my notes. A couple of things we covered. One, starting with the definition of agriculture or agricultural. We did conclude the definition of commercial purposes is too broad. And we also had a long discussion, and the committee members were encouraged to provide definitions, suggestions to bring to this meeting. And I know we received a number of them. We also talked about qualification criteria for agricultural land. We discussed that the income threshold of $1,500, which was put in place in 1990, would in 2024 dollars equate to $4,000 in today's dollars. So we also discussed possible qualifications, including gross income earned per acre, or a minimum number of acres to be bona fide agricultural, and a periodic reapplication to demonstrate that a landowner is actually an agricultural property owner. We had a fairly long discussion and a very good demonstration put on by Amanda on non-qualified ag land. And I think the thing that struck everybody the most was that picture from the Yellowstone Club, where a 1 acre tract on one side of the street had a $2.88 taxable value, and right across the street was something like $6 million. I think that something like it was a big difference. And I noticed that the committee that really struck home. So we talked a lot about the non-qual ag land, and if the acreage size is increased, will we grandfather parcels or phase in the values of those that would be affected? If we do change that, of course, there will be a significant tax effect on some parcels. The committee requested fiscal notes on some previous bills, and we also kind of discussed that the automatic agricultural classification for 160 plus acres is a separate issue to be discussed. So does anybody have anything to add to that? Those were our recap of the day last meeting. Anybody have any thoughts or suggestions before I move on to Eric Dale's presentation on past bills? Then I won't waste your time and I'll get out of Eric's way.
For the record, my name is Eric Dale with the Tax Policy and Research Unit. I'm here today to go over some previous legislation that we thought you would be interested in. So this is primarily going to go over the memo that I believe you all received in the email for this meeting. This memo was compiled by Jared Isom, but unfortunately he could not be here today, so I am here in his stead. Most of the information in this memo is based on the fiscal notes that were associated with these pieces of legislation. And I just want to take a moment to sort of briefly go over what a fiscal note is for those of you that might have the good fortune of being less familiar with fiscal notes. A fiscal note is essentially a document that accompanies a piece of legislation when appropriate. And what a fiscal note's primary purpose is to estimate the potential fiscal impact to state revenues for the purposes of developing a balanced budget as required by the state constitution. When a fiscal note is requested, it's statutorily actually required to be completed in 6 days. That usually gives the agency approximately 4 days to compile their estimates and send those to the budget office, which will ultimately compile other agencies' estimated impacts into one complete document. The point is that this is a very compressed sort of time period, and we do the best we can with the information available to us, but these are ultimately estimates and should be, taken with a grain of salt, I suppose. The other thing I wanted to point out is these are an estimate of a point in time. And as we learn more over the years, we generally try and incorporate that information into our estimates going forward. And we'll talk more about that as we sort of go through these. So first, like I said, I figured we'd go through the memo and go through some of the previous legislation that you guys might be interested in. So in 2017, there were several bills related to things that this committee has sort of discussed. And I wanted to go through those now. So the first one on the list is House Bill 27 from the 2017 session. This bill moved the 1 acre home site for agricultural properties, qualified agricultural properties, from a production value to a market value. It was estimated at the time this would have affected approximately 30,000 acres or 30,000 farmstead properties. And the estimated impacts to the state from the state 101 mills was approximately $900,000 per year. The next piece of legislation I thought would be of interest to this group was House Bill 28 from the 2017 session. This bill increased the threshold to qualify for agricultural income from $1,500 to $3,500. And some of the things I wanted to just point out about this bill is the department doesn't have great information on this type of information, or this change basically. We don't know the income of a particular agricultural property after it applies. So these estimates were very difficult to come up with, and there's a lot of assumptions that were made that would be important to the overall estimate, but may or may not be accurate, I guess is the point I'd like to make. And one of the reasons I wanted to make that point is I know there's been discussion in this group of similar types of proposals, so bear that in mind when estimates are presented to you, I guess, is the point I'd like to make. But in any event, this particular piece of legislation at the time we initially estimated would have generated approximately $4 million per year. As we'll talk about a little bit later, that's likely an overestimate for some reasons we'll get into. But that is what was in the initial fiscal note. In addition to changing the income thresholds for qualified agricultural properties, this piece of legislation also would have required all agricultural properties under 160 acres to reapply, which came with some additional expenses that were reflected in the fiscal note. The last piece of legislation that I wanted to point out from the 2017 session was House Bill 75. And this bill would have eliminated non-qualified agricultural properties altogether. We initially estimated that this would have increased values on approximately 800,000 acres and generated an additional $34 million annually in state tax revenue. Again, this is likely a bit of an overestimate, and we'll sort of get into why that might have been the case, but that was what was initially estimated. The other thing that was important about this bill is we also estimated that there would have been a significant number of properties in non-qualified status that would ultimately apply to become agricultural status, and that would have created an additional workload on the department, and the expenses for that were also reflected in that fiscal note. The other proposal that the committee was interested, there wasn't actually a fiscal note produced for this, but it was, the department worked on this extensively prior to the session, and this bill wasn't ever introduced, but we do have information on this DOR proposal. What the proposal would have done was essentially change the minimum acreage requirement for non-qualified land from 20 acres to 40 acres. At the time, we estimated this would have impacted approximately 17,500 properties and generated an additional $4.5 million in state revenue. Those are the bills that we thought would be most interesting to you and summarized in this document. There were a few bills from last session that affected qualifications of parcels over 160 acres. There wasn't a lot of information that we could provide with you, or provide good estimates on the fiscal impacts of those, but they did sort of ultimately lead to the creation of this committee. So shouldn't be totally discounted. And with that, I guess I'll pause there to see if there's any questions on this part.
Thank you. On the DOR proposal from 2023, would it have required any additional staff in the department in order to administer the change from 20 to 40 acres for non-qualified?
Minimal. I mean, again, there likely probably would have been some of the non-qualified properties would have ultimately applied for agricultural status. We may have seen a slight increase in workload, but thank you, likely minimal.
I have a question. On that House Bill 75 from 2017, you talked about the increased administrative costs for, was it the application and the filing every year? Couldn't we have that filing in conjunction with the biannual reappraisal process?
Representative Beard, I believe that's true. House Bill 75 and the fiscal note associated with House Bill 75, we assumed half of the properties that would no longer receive non-qualified status would ultimately apply for agricultural status, and then half of those would ultimately be granted agricultural status. That was a 1 year type scenario. It wasn't phased in or anything to that effect. You could certainly structure it that way, have people reapply on a biennial basis. That would presumably create some additional work. How expensive that would be hard to say. We'd have to look into that. Hopefully that answers your question.
As a follow-up, could we not use again the Schedule F filing to potentially continue recognizing those as agricultural properties if in fact they initially applied and were successful in attaining that status?
Representative Thane, I don't know all that much about Schedule F. There is a presentation a little bit later on that we can discuss more of that. I know from past experience that Schedule F information may not be a complete picture for all the properties. So that would be a situation where the devil would really be in the details, and it would be up to the policymakers to ultimately define how we use that Schedule F information. But thank you, it's certainly out there.
So on your fiscal notes, you have the impact of the state equalization mills and probably the university 6 mills, 1.5 yet. How did it affect the local mills? Did this become new revenue, or did the increased taxable value drop the mills? And this $4 million, that's a cost to the people that own that property. Their taxes are going to go up by that much, by 5 times, probably that much. Right? If it's $4 million for the state, it's $20 million across the local government and the school district.
Yeah.
But did they adjust their mills, or does that new money?
Mr. Story, first of all, the fiscal note is ultimately focused on only state revenues. The impacts of counties are, let's just say, less of a focus of the fiscal note. We did look at that. I believe we sort of put information in there going both ways because we weren't really sure whether or not that would be newly taxable or not. I don't believe it ultimately would be, but I'd have to look to the property assessment division.
Yeah, I mean, based on the current definition, it's the first sale from a subdivision when that changes classification is what triggers newly taxable. So just a sweeping change in statute, we don't believe would fall under the definition of newly taxable. So yeah, on the local side, it would be a shift in those local jurisdictions through 1510-420, lowering the number of mills they would have otherwise levied, shifting those local taxes from the current taxpayers to the newly classified group that lost non-qual status.
And the second question, if you know the answer to it, is all of this non-qual developed property, or is some of it vacant lots?
some of it is certainly vacant lots. It's anything over 20 acres between 160 acres that doesn't qualify for agricultural status. So that could be a host of things.
So several years ago, the department lost a battle in Broadwater County about taxing lots at market or something other than agricultural value when they were plotted out, but the use had never changed.
And we had to, that was in our administrative rule, if the property was subdivided and it had services to it, then we would pull it out of agricultural status or non-qual status and we give it market value. The problem with the case was that that current property owner was still paying it. It did have curb and gutter, it had power to these lots, but he was still paying it. So its use technically was still agriculture. So that's why we lost that. And as a result, had to pull those requirements out of administrative rule. And so that has kind of created a bit of a problem with those subdivision folks that, you know, their whole intention is to hold it until they're selling the lots off and then they're gonna keep their non-qual status until they've sold all of it. Lots are became uncontiguous anymore.
All right, well, no questions at the moment. The next topic of discussion is the estimated impact of changing income requirements for classification. So the next 2 points on the agenda are essentially some estimates we came up with that mirrored some of that legislation. We tried to update those estimates. I wanted to start with the estimated impact of changing income requirements for agricultural classification. As I mentioned earlier,
for those online, these were just handed out to the committee this morning, but they are posted on our website. So Bill, maybe if you could just throw the link to that committee landing page in the chat where all of these documents are available to those people that are joined via Zoom.
All right. So this is along the lines of House Bill 28 from the 2017 session. And as I mentioned earlier, the department doesn't have great information, and we really struggled in 2017 with determining how we would estimate the impact of such changes. And we continue to struggle with the data as we went to update it. However, the best information that we could come up with came from the Montana Agricultural Statistics produced by the USDA. And within that report, there is the census of agriculture, number of farms by value of sale. And that table is presented in the documents, I believe. Yep, excellent. So this was the basis for the information we used both in 2017 and when we went to update these estimates. And the way we use this, what we did is we essentially looked at the number of farms who would qualify under the lower income limit and then compare that to the number of farms that would qualify with the revised income limitation. And we determined that that was, using the 2017 numbers here, to be approximately 27% of these farms would no longer qualify, that had previously qualified, would no longer qualify with the increased income exemption. Or qualification, excuse me. And as a little bit of background, initially that was all I was going to go over in talking about this point with the limited amount of data we have of what is out there. However, when I was looking at the estimates for House Bill 28, I realized there were some assumptions and calculations that were made in that estimate that are no longer reasonable and likely differ from an estimate we came up with today. So I did want to go over what the updated estimate is and why it would be different than what was initially presented in the fiscal note for House Bill 28. So in order to estimate what the impact of this would be, we essentially needed to segregate properties into 3 categories, basically. those properties that were between 0 and 20 acres, between 20 and 160, and over 160. All the properties over 160 are automatically qualified, so this wouldn't affect them, so we can just leave those alone. For the properties that are between 20 and, or excuse me, between 0 and 20 acres, we need to develop a market value for those properties in a similar way as Class 4 residential properties, as that would ultimately be the effect of those properties no longer qualifying for agricultural status. And then for properties between 20 and 160 acres, we would need to determine the market value and taxable value associated with non-qualified land as opposed to the qualified agricultural values. In the initial fiscal note, the ownership component and contiguity was not properly accounted for, and that led to more properties being classified as under 160 than there truly were, and then more properties in the 0 to 20 group as well. This was ultimately caught, and we did develop a revised fiscal note, but by the time that happened, the legislation had been withdrawn and that revised fiscal note was never ultimately published. But if it had been, it would have gone from approximately $4 million per year to approximately $1 million per year. So as I said, the next step is developing market values for those properties between 0 and 20 acres. And to do this, we took the acreage of those properties and calculated what their values would have been according to the land models developed by the Property Assessment Division, as if they would have been Class 4 residential properties. And this is in contrast to what we did in House Bill 28, where we used a per acre average essentially. And the reason that probably wasn't a great assumption is because these properties tend to be larger and not necessarily representative of the average residential property, if that makes sense. So we weren't necessarily accounting for the diminishing marginal price per acre of these larger type properties. So by using the actual models, we feel we have a more accurate representation of what those values would have been. One caveat to that is these models were generally developed for properties of smaller sizes. So we're likely undershooting what those values would have been slightly. However, the degree to which we underestimate those values is probably less than the degree we overestimated them at House Bill 28, if that makes sense. So once we have that, the next step is to estimate the market value or productivity value of the properties in 20 to 160 acres that would no longer qualify, or as if it did not qualify. So one of the big things that happens, or differences between non-qualified land and qualified agricultural land, as you may know, is the tax rate is for non-qualified properties is 7 times that of qualified properties. And that change was reflected in the fiscal note for House Bill 28. However, one thing that was not reflected, that is my fault essentially, since I compiled the fiscal note for House Bill 28, was the productivity values weren't changed for those, and they should have been. Productivity value for non-qualified agricultural land is based on grazing values, which is often substantially lower than other types of values or other types of agricultural property. So that was not accounted for as it likely should have been in the fiscal note for House Bill 28. But in any event, once you make those adjustments and calculate the new productivity values and taxable values for the 2 categories of properties that will be affected, add the totals together and then multiply by 27% of the farms that we felt would no longer qualify under the new income requirements and apply the state mills. And as you can see on the table, that leads to an increase in state taxes of approximately $300,000 per year. So quite a bit less than the initial $4 million per year we were estimating. I'll pause there to see the questions.
Yeah, I'm lost. Where's the 300,000 on the chart?
It's at the very bottom of the table, state tax.
340.
Yeah, so under current law with $1,500 limit, or not limit, qualification, we're estimating that these properties would pay approximately $48,000 in state taxes, and if they lost that agricultural status, they would pay approximately $340,000 for a difference of $292,409.
So Eric, just for illustrative purposes, taking, you know, a statewide average of what, roughly 600 mills levied by the counties, total cash out of pocket by these properties would be 600 mills plus the 95, right?
Correct. That
So,
would be
what, 6 times that 300,000, right?
yeah, that's roughly speaking.
So $1.8 million in additional taxes paid, local and equalization money, correct?
Correct.
Everybody follow that?
The difference between the 300,000 and the 1.8 million calculation you did would also be reflected in lower taxes for all other property taxpayers. Given the size of the states, that would probably not be very large on any individual property tax payer, but added up. That makes sense.
Got one copy. Yeah, 1.8 million bucks spread out over what, 800,000 properties?
Well, and truly, it kind of depends on what the density of these non-fall parcels are, because of course in Gallatin County, a handful of these are gonna have a bigger impact than in eastern Montana where the market value isn't very high, and most of those are qualified ag anyway.
And this is the qualified piece. So this is the going from essentially qualified agricultural to something else, which could include some non-qualified lands. Most of the impact will be borne by those properties between 0 and 20 acres, going from a productivity value to a market value. But yes, it will depend on where those properties exist and how representative they are of all the assumptions we previously made in their income in various situations.
So if I may, if I heard that right, then it actually could be quite a lot more than 1.8 million collected. I might be wrong here, but if a disproportionate number of these properties are, let's say in the Gallatin Valley, their market value could be quite high, which would increase the amount of taxes paid on those properties, right?
Correct. Again, this is looking at all agricultural property that is qualified and what would happen if you no longer qualified for agricultural property, and the non-qualified issue is a bit separate. I didn't calculate a mill shift for this particular scenario because the overall change in taxable values was not as large as we initially did. But when we go on here and look at some of the other scenarios concerning non-qualified agricultural and changes to the way that's taxed, we did go through the process of calculating what the revised mills would be and tried to show how that would affect other classes of property. So stay tuned.
So the big impact of like going to $3,500 is gonna affect for people who are non-qualified now, that are probably just grazing. They're not gonna be able to make the animal unit months to become qualified.
That's true, because animal unit months are calculated based on the income requirement of $1,500 currently, which is 25 animal unit months right now. If it goes up to $3,500, that animal unit month is gonna climb, and yes, it could kick folks out.
But if a person was producing some kind of a crop, you could probably stretch to 3,500. So I mean, that's going to be the break point. It's what its ability to do, if you know, it's grazing land or if it's irrigated.
So oh, sorry, Eric, that was, you actually kind of led into the question I was going to ask earlier. You get a sense for how many people were no longer going to qualify if you made the shift? And I apologize if you said that already.
No worries. No is the short answer to that. The best information we have is, like I said, coming from this table that just shows you know, the number of farms by value of sale. And there are some heroic assumptions made in this analysis, right? Like farms are not acres, farms are not properties, but this is the best information that we could find to help estimate that. So, and ultimately, we just said 27% of the population that previously qualified will no longer qualify. That's going to vary substantially depending on your area and depending on the types of farm product being produced. And we have no way of really knowing what that is, which again leads to why we have difficulty in this estimation.
I think it'd be useful to ask the people online if they can hear what we're talking about. I know when I sit online, lots of times you don't speak loud when you ask questions. I'm sitting right by the mic, but I know Bryce is way down there.
I'm not a Zoom or Teams Zoom. Looks like there's some Q&A going on too. I don't know if Bill has.
Bill, can you hear everyone all right?
Yeah, I can hear everyone.
Line. I thought somebody's hand go up.
I'm just saying that I can hear everybody fine.
Clarifying question about, so the number of AUMs was based on $1,500, and what year was that?
So each reappraisal cycle in statute, MSU has to perform the analysis, and they tell us what the current AUM based on commodity prices is. So that number for this cycle is 25. It fluctuates. A couple cycles ago it was 32. It's been as low as like 20, 21. So that changes every cycle, and MSU performs the analysis for us. That they basically look at the commodity price and have a formula and calculation that says this AUM is what currently equates to the $1,500 threshold.
If you rented that grass to somebody with cows or sheep or whatever, right? So it's the other way of what you thought, Scott. It's not 25 bucks an AUM. It's 25 AUMs to arrive at the $1,500 in revenue if you rented that grass.
I think the answer to that is maybe in 2009, that's when they started having the MSU do that calculation. I think. When we
2009 is when we changed all of those egg rolls. And
changed all the stuff of productive soil type production.
That number through time has not changed. You could take a 2009 value of an AUM, and put inflation on that. That doesn't work that way.
So if 30 bucks an AUM, you know.
But it's gone like this.
Yeah, it's definitely created some issues. Everything gets adjusted each reappraisal cycle as far as our productivity value based on the 10-year Olympic average. The same for this calculation. That's cause issues because you might have someone apply 1 year that gets denied because the AUMs that year is set at 30, and now this cycle when it drops to 25, maybe they were at 27, so now they qualify. We don't really do a good job of tracking those individuals, and we certainly don't each cycle kick people out because that number went out up, and then reach out to someone who applied 10 years ago that might now qualify. That would just be administrative challenge to do that. So I think that there is an ag advisory committee that kind of has some purview over these things. I think that's one item we want to bring up with them this next go around is there a better way so that that AUM number is more consistent and constant over time and not adjusting every 2 years and sometimes pretty significantly.
Well, the other unintended consequence of that is when you're saying, well, you got to have 160 acres and $3,500. I don't know how close the department tracks that, but not every quarter section is 160 acres. And you got tracts and you got the way the earth is shaped and stuff like that, and so you might own a, I think, you know, there's still some old 160-acre homesteads that people inherited that are out in somebody's ranch. The ranch just rents them, you know, because they have no value unless the person wants to sell them. They would probably don't produce $3,500 in rental income, and they're 158 acres or something like that, you know, so they're not, I mean, they're probably scaped by being all over 160 because they're a quarter of a section. I don't know the answer to that.
So they don't, if you are 158 acres, even though you are a section on the map that doesn't quite equate into 160, you would have to apply for agricultural status because your number isn't 160.
So some of those have been swept up in this.
Yeah.
I always thought it used to be that if you had a parcel like that was part of an ongoing operation, whether owned or rented, that it was automatically in, but I don't think that's the case anymore.
So there are different requirements for that. It doesn't have to be contiguous, but if it's an integral part of your operation, so this is where the sale barn is, and it's not contiguous with your grazing operation, that sale barn parcel can still be included in your total number of acres because it's integral to your operation.
But that would have to be filed for.
It would have to have an application.
Being no further questions, I think we'll move on here. So the next bit on the agenda is similar. We updated some of the estimates again concerning how non-qualified properties are taxed and what those changes would look like.
Eric, can I interrupt just real brief? Just at the risk of being rude, I've got to testify at the interim budget committee at 11. So if I just get up and walk out, Scott will take over any chair duties necessary.
All right. So the first scenario that we wanted to look at was what the impact would be of simply eliminating non-qualified agricultural status. And that is on the first page. And this is similar to House Bill 75 from the 2017 session. So in order to make this estimate, what we had to do was essentially determine a market value for each of the non-qualified parcels. And as I sort of alluded to before, in the 2017 session, we were using per acre averages and applying those to the non-qualified parcels. That was probably not an appropriate assumption. So what we've done since is we have taken the actual acreage associated with those parcels and plugged them into the actual land models provided by the Property Assessment Division, or more specifically, Property Assessment Division did it for the tax policy research unit, which was incredibly helpful. And then once we had the updated market values and taxable values, we took those new taxable values and added them with the existing taxable values that didn't change, and we recalculated what the mills would need to be for each of the local taxing jurisdictions in order to generate the same amount of revenue, essentially. Then we took the total mills, including the state mills, which didn't float, and applied those to all the properties to sort of see how this would impact the other types of property and not, well, how it would impact non-qualified properties, but all other types of property as well. So if we look at the summary presented here for this scenario, I wanted to go through this table basically. So the upper left-hand corner is the statistics associated with current law. The upper right-hand table is those same statistics, so market value, taxable value, mills, and taxes, that we estimated based on the elimination of non-qualified agricultural land. The bottom left-hand table is the absolute difference between those two, and the bottom right-hand table is that difference presented in a percentage change terms. Then within each of these tables, I want to run through the statistics that are there. Like I said, there's market value, taxable value, mills, and taxes for various types of properties. So the first set of properties is agricultural properties. This is divided between qualified and non-qualified agricultural properties. And then we also presented the numbers in terms of a per acre value in addition to the sum total across the state. The next set of numbers is class 4. Total is presented there, as well as a breakout of the class 4 residential property values and the class 4 commercial property values. And to make these numbers more meaningful, we also presented the median value home statewide and the median commercial value statewide. So in 2023, the median residential home was $325,000. The next set of numbers, essentially everything else. So we broke out the business equipment tax, that's class 8 property, personal property, things of that nature. Class 1 and 2, which are net and gross proceeds, excuse me. And then lumped everything else into an all other category. That all other category is primarily, not exclusively, but primarily in the centrally assessed properties. So the railroads, pipelines, telecommunications, things of that nature. So by way of example here, I thought I'd kind of go through some of these numbers. If you jump down to the total change in value and look at class 4, either residential or commercial, you can see there's 0 change in market value and 0 change in taxable value, which makes sense because eliminating non-qualified properties wouldn't change those values. Another thing to keep in mind is the non-qualified amounts in the class 3 portion of the table reflect what they are currently valued at. So in this case, these non-qualified values would be moved to class 4, but we left them separate so that you could see the impact on these properties and it wouldn't be sort of washed out in the overall class 4 numbers. In any event, as the table shows, the average statewide increase per acre of moving these non-qualified properties to a market value would be a change of $7,295.61 per acre, which would equate to an increase in overall taxes of $38.91. Like I said, we did include the class 4 properties there as well, including the median value. So you can see that overall statewide average mills for residential property would float down by approximately 7.5 mils, which would equal a reduction in ad valorem taxes of $33.02.
I'm not following any of this.
Fair enough. Apologies.
I'm not seeing that. I'm either on the wrong table or not finding any of the numbers you're talking about.
Okay. Apologies. If you can't understand it, then that's a problem because you probably know more about taxes than most.
Well,
so
It's in the bottom left.
first page, yep. So the total change here, we have agricultural land, so that's all agricultural land. So you can see the mills for all agricultural land would float down by approximately 41 mills, statewide average. That would increase to, or that would be an increase in total taxes for agricultural properties, again, including the non-qualified pieces of $43 million. On a per acre basis, that's an average increase of 87 cents per acre. The next one down, you'll see, is the qualified agricultural production. Again, that wouldn't change because we're not making any changes to properties that currently qualify, right? We're only making changes to those properties that are currently in non-qualified status. However, these properties would benefit from a reduction in mills because of the increase in taxable value associated with this. In total, they would see a decrease in total taxes of $784,258, or a per acre amount of 2 cents per acre. And then if we look at the non-qualified piece, again, this is where the change is because we are eliminating the status. We would see their increase on a per acre amount is $7,295.61. The taxable value per acre would increase by $91.06. The statewide average mills would decrease by 39.37 mils, and they would see an increase in taxes of $38.91 per acre. And then if you jump over to the next table to the right, those are in percentage terms, if that makes sense. And you might be asking yourself, why is the decrease so much greater, and decrease in mills so much greater in non-qualified parcels? Because that's where the biggest impact is. So, for example, the residential property is spread out all over the state, and there may be areas where there isn't as much non-qualified land, but in areas where there is, they tend to see a larger decrease in mills, if that makes sense. And the next three tables are all laid out in a very similar fashion. So certainly, if you have questions, please express them, and I will try my best to clarify.
So, eliminating non-qualified agricultural land, does that land then become class 4?
Correct. And under this assumption. So,
And, we kind of talked prior bills and how we did those estimates. This one didn't do anything to assume that a certain number of those non-qual parcels would switch to qualified status. This is just assuming they all go to tract. There would be a subset of that population that would be able to qualify. This analysis just is not accounting for that. This is the, I guess, the
upper limit.
Yeah, the maximum that you would see things increase. But there would be at least a subset that would be able to qualify under the current rules and would go through that process because it would, benefit them to do so.
So part of the discussion we had last time was potentially changing the non-qualified to a 40-acre minimum. Did you do any analysis to disaggregate that data so that you could look at changing or eliminating non-qualified, those parcels between 40 and 160 potentially applying to be qualified, and what those impacts might be?
Well, that's a great question, because that happens to be in the very next table.
Before you go there, one more question. The lower left, so you got the total at the bottom, and the 13.2 million is kind of the last figure there. That's new revenue, and that's just is that as a result of change in use, or is that something?
That is the result. That's the overall result of essentially the state mills that
Okay.
we assumed did not float in this analysis. So yeah.
But those non-qualified parcels are gonna kick in $44 million more across the whole process.
Correct.
By the time the mills flow everywhere, a bunch of that turns into tax reductions for other classes of property.
Correct, and that is also listed there, so you can see the $44 million increase in these non-qualified properties would translate to a reduction of $24 million for class 4. 20 million of that would be residential, 4 million would be commercial. Business equipment would see a reduction of approximately $1 million, and all other property, which again is mostly essentially assessed property, would see a reduction in taxes of $4.3 million. Clear as mud.
Well, in my wallet, 24 million would look great, but across the state with the number of residences paying class 4 property taxes, it probably doesn't equate to much.
$33.02 for the
And 2 cents.
median homeowner. Based on all of these assumptions, which are just that assumptions. So moving on, the next table is exactly what Representative Thane mentioned. So, and this is similar to the department proposal from the 2023 session. And under this scenario, the minimum acreage requirement for non-qualified land would be moved from 20 acres to 40 acres. So this presents all the same information. As we can see from this table, this would cause a decrease in the median homes ad valorem taxes of $18.32, which would be the result of a decrease in 4.18 mils. The non-qualified, the average per acre taxes for property currently in non-qualified status would increase by $19.10 per acre. That makes sense?
I think if you look and compare the two numbers, you see that that both values don't change that drastically. And that's the indicator that the vast majority of non-qual parcels fall below 40 acres. In between that 20 and 40 is the vast majority of all non-qual parcels fall within that size range, which is why you see these numbers not change all that significantly from completely eliminating it to just upping that threshold of 40 acres.
All right. And the last scenario that we looked at is not necessarily making changes or eliminating non-qualified land, but rather changing the per acre value of non-qualified land from $54 to $550 per acre. That number could be, we could look at any number you wanted. That's just a number that I heard thrown out at the last meeting, I believe, or somebody somewhere decided that's what we should look at. So
it's the lowest value irrigated land. Lowest value of our irrigated land was that type of
Would you repeat that? Repeat what you said.
The 550 number was the lowest irrigated per acre values.
So right now, non-qual is using the average grazing, and this would be changing that from the average grazing rate to the lowest irrigated rate.
And then continuing with the 7 times the qualified agricultural tax rate.
Robin, the irrigated rate, most of that is really the same as the highest dryland rate, isn't it? But I mean,
yes,
you can't deduct your irrigation expenses to take you below what it would be if it wasn't irrigated.
that's right. You could consider it the highest dry land or the lowest irrigated. That rate is similar.
I'd rather call it highest dryland, just because a lot of it isn't irrigated.
Right, yeah, that's true.
Under this scenario, the median home value would see a decrease in their ad valorem taxes of $25.81, whereas the non-qualified parcels would see an increase in their taxes of $33.98 per acre. They would also see a market value increase of $496 per acre, which is what we said it would be. That would be 550 minus 90 or 54.
Did you give us this number one time? How many of the non-qualified, what percentage of non-qual is below 20 acres?
I know we know the average non-qualified parcel was 25 acres. I don't know if we know exactly how many of them accounted, how many of them are below 20 acres. Part of the tricky part is the contiguous piece of it. And while 2 parcels might both be 11 acres, together they're 22, and they're owned in the same ownership. So it's kind of hard to really quantify that based on that contiguousness.
I would think a lot of it resulted from the 1970 subdivision law where everybody broke to 20s or in that range. and to grandfather in forever. So most of them are that. I mean, unless somebody bought 220s, or I don't know if anybody's subdividing into 40s.
Yeah, if you're talking under 40 acres, I think it's close to 75% of all non-qual acreage falls below 40 acres. The under 20, really the only thing that should be under 20 is if it's with forest land. Say it's forest, it's 17 acres and the remaining 5 acres, because if total parcel size is over 20, that 5 acres that doesn't qualify for forest would then default into the non-qual status. I mean, otherwise, in theory, if we're doing things correctly and have all our information right, there would be no true parcels under 20 acres in size that get non-qual.
However, once you've subdivided your lots and went through the whole subdivision process, and you still own, as the developer, own all 39 acres of your 160 parcel subdivision, all 160 of those parcels are getting non-qual until they start selling. And
even when utilities are brought in.
Yeah.
All right. Almost done, guys. Thanks for bearing with me. There's another table, it lists all the counties. So we took those 3 scenarios, eliminating non-qualified status altogether, changing the minimum acreage to 40 acres, and then increasing the value to $550 per acre. And we calculated what the average mill shifts would be for each of the 56 counties, what the change in median home value taxes would be, and then what the change for a $100,000 home. So if you wanted to know what the change for a $200,000 home would be, simply multiply these changes by 2, $300,000 would be multiplied by 3, and so on and so forth. And then lastly, we sort of summarized these estimated changes similar to what you'd see on a fiscal note. So we have the state impact from the 95 mills and the 1.5 mills, the university impact from 6 mills, and then the statewide taxable value change for each of the 3 scenarios. And we did forecast these values for tax year 23 to 26, 4 years, much like you can see in the fiscal note. There are a few differences that I thought were important to point out. Number one, as we mentioned earlier, if you did proceed with making these changes, presumably there would be a large number of properties that would apply for qualified ag status, and that has not been reflected in any of these estimates. It's sort of an upper bound, if you will. The second thing that makes these a bit different from fiscal notes is that the work associated with processing those applications has not been factored into any of these, but that could be substantial depending on how that was structured. And then the last thing I wanted to point out is when you make broad changes to the taxable value statewide, generally that will have feed-through effects to the school funding formula, which can be quite significant for the state general fund in terms of GTV aid. I don't know enough to estimate those numbers, so they are not.
It will generally be positive for the state because they're driving values up, which probably reduces the need for state aid in some of those areas.
You would think so. I think there is some component of essentially how equal the distribution is among schools, and would this make that distribution more or less equal? It's difficult to say, and how that would feed through. I leave that to the smart folks at the Office of Public Instruction.
But I would suggest, and again, without any analysis, that there's minimal fiscal impact, but it is really about how the money is distributed. So you're still going to collect the money in the pool based on the 95 mills. The formula will be adjusted based on the taxable value of each school district, and the distribution of that money will change, but it's not going to result in a windfall really to the system. because of the fact that, well, you've got House Bill 587 coming online, et cetera, that will have some impact on reduction in the counties.
Yeah, everybody's subsidies relative to the whole, right?
That's some go up. That's some will go
This
up and some
didn't
will go
get
down.
rich or this one gets relatively poor, so money that would have gone there.
I think that's true.
You know, the other piece of the non-qualified is that 7X tax rate. Would, in one of these scenarios, you know, I guess scenario 2 or 3 here, would eliminating that tax rate have much of a fiscal impact?
We haven't necessarily looked at that specifically. I think most of the impacts, at least in the first 2 scenarios, comes from the values going from a productivity value to a market value, which is generally more than the multiplier you would see in looking at the difference in the tax rate, if that makes sense. And that's kind of what you see when you compare the different types of agricultural property as well. Like there could be instances where a non-qualified property would pay less in overall taxes because the value of irrigated land, for example, is 7 times more than that of grazing. So even when you make that tax rate adjustment, the non-qualified classification is better than irrigated classification. If that makes sense. I hope that answers your question.
It's not illustrated in these numbers, but if you're thinking of it from an equity standpoint and looking at those 3 scenarios that are outlined, either eliminate non-qual, bump the threshold versus changing the value that's associated with it. The option 1 and 2 do a better job of actually equalizing, because now you're treating those properties in those counties similar to properties in those counties. Whereas if you just increase that amount that non-qual is used to value it, you're gonna, because of the diversity of the state, you're gonna see hugely differing results. Like your Gallatin County, that's still probably only gonna be, you know, a 10% of what that value would be if you were in market land. Versus if you go to Richmond County, in some of those eastern counties might now have actually pushed them where it's less beneficial to be in non-qual status, and they would be better off getting their land valued at tract land, because that $550 per acre value might be truly less than what the market value of those properties. And we kind of looked at that, and you have a range from maybe a 3% where non-quals coming in at 3% of what market value would be, and say your Gallatins, Flatheads, Missoulas, versus, you know, maybe that's only a 30% discount in some of the eastern counties. So you think of it from that standpoint, you're not doing as good of a job of equalizing values across similar properties with adjusting that amount. And you're going to be seeing varying results pretty drastically across the state based on just where that property is located, versus the other methods of moving everything to the market does a better job of truly equalizing value amongst properties in those areas.
Has anybody ever litigated that equalization question on the current system?
Not that I'm aware of.
Don't get any ideas, Bob.
Me and I are gonna talk later.
So the second to last chart, is that in order of license plate number?
Yes, unfortunately.
Yeah, I was kind of scratching my head.
Finally figured that out.
Yeah.
Sorry about that, yeah. The property tax data is organized that way, and
Okay,
we left it, probably.
just always remember Butte as number 1.
We're 1 on your license plate, number 1 on your card.
That's right.
Eric, what's the practicality of making this kind of a shift? I mean, it's gonna be a huge effort on behalf of the Department of Revenue and require a lot of staff. Is there a cost benefit analysis of making this shift?
Truly, I think the only costs that we would be having to deal with are those that no longer are in a non-fall state and they go to tract land may apply for agricultural classification. So there would be a certain number of them that we would have to process agricultural applications to see if they would qualify or not. I think that's the biggest impact to us, would be that application process.
Yeah, I mean, systematically, just eliminating non-qual, we could do that in a mass job and just say, okay, these are now put in as market land. So yeah, as Robin said, the work is truly trying to estimate how many more applications our staff are gonna have to process. And we go through we meet with our managers and our staff and we assign time to these tasks. So say like, it would take 2 hours to work through your typical ag application. And that's what we would use good and back at the fiscal notes and impacting or estimating the cost to us. So we would try to do our best to anticipate how many applications we would expect to receive. And then we go through our allocation and say, okay, we're going to get 10,000 applications and it takes on average 2 hours to process those. That equates to a total number of hours. And then you could divide that by essentially your 2080 to say, okay, that's an additional 3 FTEs workload to process 10,000 applications that we otherwise wouldn't have received.
We have a question online.
Yeah, this is Brian Campbell in Lake County. I was wondering if we could see that table that listed the counties again, and maybe just as an exercise to help clarify things for me. It showed Lake County, I believe, as having the biggest difference. Am I right? $77.08.
Broadwater's 140.
Oh, Broadwater, okay. So, well, in either of those instances, would the explanation just be because the market value of the land is just higher? So if you're switching to, class 4.
Yeah. The other thing that you would have to consider is what the impact of an extra dollar would mean to some of these counties. So for example, you see Mineral County, Jefferson County has a rather large amount, Broadwater County. There simply isn't as much taxable value there. The tax base isn't as big. So making these changes could potentially have a bigger impact on the overall mills, if that makes sense. So that would need to be considered as well.
I think the other thing this chart is doing is it's looking at the median home price for each county. And clearly the median home price in Lake County is larger than the median home price in the county above, which is Custer. So that's why that's making that look bigger also, is because of the median home value.
Okay, but there's more than one factor.
A closer comparison would be the $100,000 home value, because that is equal across all counties, where the median is dependent upon the values of the homes in that county.
Okay, right. Thank you.
Marcus, do you still have a question?
It was answered. Thank you.
Must not be any non-qualified land in Weevil County.
Yeah, I think it's really not. It's either ag land or BLF, right?
Well, the other thing is, again, to Bryce's point, the difference between the productivity and the market value in Weebo is probably not as great as it is in some of the more urban counties.
I think there's actually, and again, this is under the assumption that we could just plug these into our existing market models. We would probably have to tweak those to some extent to account for larger acreages. But I think even Daniels County right now, the market value is about the same as what the non-qual value is. So the non-qual is actually paying more in taxes because they have that 7 times tax rate, whereas some of that market value isn't as, the discrepancy isn't as large. So I think there's one county right now where just where those parcels are, we plug them into the acre model for that area. They would actually be better off in tract land and getting market value because the difference in the value isn't that great, but then that 7 times multiplier on the tax rate really comes into play. So that's the only county I think currently where there's properties that might be actually worse off with a non-qual value, because that, again, that market value discrepancy isn't as large, and then that 7 times multiplier on the tax rate really shifts it.
And again, you can see that in the Dan Mills County one, you can see the mills actually increase in that area by 1.3 mils because the overall taxable value went down. Wouldn't be normal, but or Daniels County.
For the median.
That's right.
Would it be accurate to say that eliminating non-qualified ag land would be the most equitable way to adjust rates for market value, just like any other? If you have a residential property or commercial property in Helena versus Missoula versus Bozeman versus Evo, and it still allows people that are truly ag producers to then apply and qualify for ag tax rate.
Yeah, I think it would probably be safe to make that assumption, because again, that is better aligning similarly situated properties. Like if you went back to the presentation last week when we were showing you those parcels that are truly next door to each other and have a 1/10 of an acre size difference, and one gets this and one gets the other, and they're probably neither of them are being used in an actual agricultural capacity, then yeah, eliminating it does the best job of equalizing that across all the counties versus the discrepancy you have now in your Gallatins where you're getting a 97% discount because those values are so disproportionately aligned versus your Daniels County where they're so much closer. You're, maybe in Daniels County, there's the negative effect, but there's some counties where that difference is only a 10% discount, 20% discount. And when we kind of looked at that, that's what we saw. I think currently, like Gallatin, I think was the lowest, and it's a 97% discount when you compare those values. And then that ranged, in some of those eastern counties, that's only like a 20-30% discount. So that's where looking at those 3 options, the last one does the worst job of equalizing it and doing so globally across the state, just with how different it is versus in that county, you're equalizing those parcels for that county based on the values in that county.
And then a follow-up to that would be, is there any other classes of tax property where we see the same thing as like non-qualified, where you're really not based on market value, you're based on just a set?
So the classes of property that are not based on market value, that are based on the productivity values, class 3 agricultural. So your qualified ag and non-qualified ag are based on a productivity value. And then your class 10 forest land is on a productive value. Everything else is at market value, but with the classification system, residential piece of tract land is market value at 1.35% tax rate, where centrally assessed property is at a 3, 6, 9% tax rate. Now, with how those are valued, I don't think we want to get in the nuance of unit valuation versus what we do on class 4, but there is still, even though those properties aren't getting the productive value and are closer to market value between them, there's still the discrepancy in the tax rate that gets applied to that value based on what classification they fall into.
Right. So most other classifications across the state are based on market value for that county versus
whatever it is, residential, commercial, they're more closely aligned to market value.
It's, I mean, again, with centrally assessed and the unit valuation and allocating it back, it's quite as apples to apples. And
yeah, well, I was just gonna toss this out there as well. There's also railroads, which are valued using a formula, and that is how the legislature has said this is how the value for tax purposes, property tax purposes, is going to be done. It generally is a reflection of what would otherwise be market value, but I think you can probably have some different opinions on that. It's just the legislature set forth railroads are valued using the formula, full stop. So there are some discrepancies or differences, I guess is a better word, in terms of how different types of property are valued.
Are the online people able to hear that? Tony's a little ways from the mic.
I can hear you fine.
Robin, I have a question. Have we noticed a number of parcels, any changes in the last 10 years as to new property owners coming in and claiming, taking advantage of the tax code, but not actually having it in production?
I would say within the last 10 years, the biggest problem that we're having is not necessarily people trying to apply for status, because they do have to jump through the hoops and have to prove that they are using it in an agricultural way. But it's the developers that have created some subdivisions, maybe some phases of subdivisions, where I'm gonna create 3 phases, I'm gonna get it all surveyed, now I'm gonna start developing this one. But those other 2 are sitting out there in limbo. And once my first phase is fully developed, then I'm gonna jump to the second phase. And so that seems to be more of the inconsistencies that taxpayers are concerned about, is those types of situations.
I would say there's probably been some in, again, the high value recreational type community, like the Flathead Lakes, that are meeting what the criteria are as far as the 5-year provisional status, that are doing it for the tax benefits and really have no intention of being a quote unquote full-time producer. I mean, so there are instances where people, again, aren't doing anything illegally, they're just taking advantage of what the law currently says, when at the end of the day, you know, their intent is not to be what you probably consider a bona fide agricultural producer. I mean, you can have probably $15,000 to $20,000 a year in tax savings on, say, a Flathead Lake parcel by getting that 1 acre at the productive value versus the market value. I mean, there's pretty substantial savings to go through that process. So there's definitely instances of that going on. People doing the bare minimum, not again because they have any intent of being an agricultural producer, but there's significant tax advantages and savings in property taxes to do that in certain areas. Again, not locally across the state, because there isn't a huge discrepancy, but there's certainly areas where it is of great benefit for people to go through that process.
Thanks, Bryce.
But in my own mind, if I wanted to summarize this first portion this morning, I would say that one of our guiding principles is creating a fair and equitable tax system. Number 2, I look at your numbers and I recognize that there's a significant caveat, and that's because even if we go to eliminating non-qualified, there are a significant number of people that are non-qualified that may be engaged in agricultural production who would then go through the process and become qualified. And I think that's what we intend. If you're a legitimate producer, you should get the rate. But the bottom line for me then is whether or not it has a significant impact on other classes or anything else, if in fact it's not a bona fide agricultural property, then we're going to tax it at a different rate. So I guess what I'm saying is if, number one, it doesn't create an onerous burden for Department of Revenue, and number two, if it helps us create a fair and equitable tax system, I would suggest we as a committee say it may be important to eliminate non-qualified status with the caveat that anybody can apply for the agricultural rate if they're engaged in legitimate production.
Yeah, as we kind of talked about, there are some people that fall under that 160 automatic qualifying that have, say, irrigated land where it's more beneficial to currently be classified as non-qual. So they don't even go through the process of applying to us. So there's certainly that group that would now go through that process and get qualified. I think where, again, depending on the definitions and going back to that AUM discussion, the vast majority of non-qual land is going to be grazing, not actually producing a crop. And with the current $1,500, and if we were to decide to adjust that and that went forward, it's going to be extremely difficult for anything under 160 plus acres to meet that minimum AUM if all you're doing is grazing. And that's what I would say the vast majority of non-qual land that is currently non-qual that is used in an actual agricultural capacity would be for grazing land. And even under the current 1,525 AUMs, I think with the statewide average, you're already at like 150 acres to be able to meet that threshold. So again, depending on what other conversations are had and decisions are made, that's where you would see a lot of people under the current law. If we just eliminated non-qual and did nothing else, because the vast majority of that is grazing land, they are not going to be able to meet that AUM capacity to qualify under current statute.
We have a question online. Mr. Butcher.
Yeah, the question came up and was asking if if we're seeing people taking advantage of the ability to purchase properties and maintain, those ag rates, even though they're not engaged in ag. And I do think you see that on larger recreational properties. Those are the folks, in my view, that are taking advantage of this particular issue. And I do think we need to address that. However, I do believe that, regardless of the size of property you're in, if you're actually engaged in ag and you're using it, then, I think we should try to allow for that qualification. But, we have owners of small tracts that have held on to them for years, 20 acre and under, that, try to maintain, that status, really just as absentee owners. And I think with the housing crisis issues we have, some of that, if they had to pay a little more in taxes, they might think twice about just sitting on properties that could otherwise be developed. So those are just my points.
I could dovetail on that really quick. I would say that the Montana Supreme Court, we have the Heidecker decision from a while back. There's a couple of other ones that are pretty well established in Montana. By pretty well, I mean, it is very well established that actual use is what controls the classification of the property. So dovetailing that with what was just said and with what Representative Thane was saying earlier, I think it is just that, the Supreme Court case law and everything we have right now is, if you can show the actual use is bona fide ag, then that's what it will be.
Question. What in regard, remember in the last two meetings, Mr. Smith from Lewistown area, he has an 80-acre parcel. It's not enough to qualify for ag land, but he feeds them anyway. He buys hay and feeds them there. Why, or do we have a special case for those kinds of farmers and ranchers? Because you do have those smaller acreages where they are trying to raise 10 or 20 head of cattle, and that is ag production. But the land is grazing land, and there's not enough land to qualified under the current status. So what do we do with those folks?
So there are no special exceptions for that statute right now. If your use is grazing, you have to meet the animal unit length requirement in order to be qualified agricultural. Otherwise, you're not.
And that ties back that because the land itself has to produce the $1,500 in income. And yeah, that's something that the group can certainly consider. I guess the difficulty from an administration standpoint is if you have 2 acres and you graze a cow out there for 2 days and then go sell that cow, you're gonna surpass that $1,500 income threshold, which is why it is a statute the way it is, where MSU does that calculation to say this is how many AUMs equates to the land producing the $1,500 in income, because you would certainly run into that instance of, well, I mean, yeah.
Good idea, they're probably rare, and absolutely production value of the land is critical to maintain. If we do nothing else, we don't change that.
But they don't have to actually produce anything, correct? I mean, they don't have to be grazing. They just have to meet the qualification of grazing.
So grazing is the default classification for agricultural.
But I mean, so if they qualify for the AUM, then they're automatically taxed as if they're actually grazing versus having livestock actually be there. So they get treated as if they're an ag producer, but they just have raw land sitting.
If they're over the 160 acres currently, if they're under the 160 acres, they would have to apply and then show us that they are actually grazing and using that in an agricultural use. But that's where they just fall into that non-qual status currently. So yes, if it's over 160 acres and it's just sitting there, even if it couldn't meet that AUM requirement, it gets that classification. If it's under 160 acres, it's going to be non-qual unless they go through the actual process of applying, at which point they do have to show us and demonstrate that they are using it in that agricultural capacity in order for us to classify it as qualified agricultural land. So again, that's where that kind of default non-qual just based on size comes into play.
Is that appropriate? Do we have a handle on how many thousands of acres that are out there that are over 160 acres, but nobody's ever questioned whether or not they're agriculture?
Yeah, we have no good data on that to, make that determination or even estimate what the potential impact.
We just have lots of anecdotes of something out there. There's something out there.
You were gonna say something about.
No, I think I covered, I mean, that's this whole non-qual thing, is it's an exception to the normal act. So if you want to take advantage, if you got a small tract under 160 and over 20, you don't do anything in your benefit. If you want to get a little more benefit, then you can, depending on your type of land, if you have irrigated land, you just want to be non-qual, because then you're 7 times grazing. If you're grazing land, then you might want to fight it and try to get ag thing, but it's a few dollars for a lot of work, so. I mean, the fault in the non-qual system is when they just arbitrarily said 7 times grazing, 7 times the average grazing, because then that brought in all the dryland cropland and irrigated cropland and stuff, and just opened the door for those people to say, well, I'm not going to try to qualify because that'll raise my taxes. I'll just go into non-qual. I got my 21 acres out there.
Well, I do think the discussion needs to go also, if the decision is to completely eliminate non-qual, then I think there is some discussions that need to be made about the qualifications, because not only the qualifications from the get-go, but then also the periodic reapplication. Because if I go out and buy 10 cows when I'm filing my egg application, and then I sell them and don't get any more, without the reapplication process, I'm not gonna know as the appraiser that they no longer using it. And with all of those reapplication and multiple applicants coming in because of the elimination, that is gonna increase the fiscal load, of course, because that is gonna take some staff time that we're gonna have to process that. So those are just all considerations, but I think valid considerations on the qualification piece of trying to make sure that people aren't finding a loophole to jump through and still allowing the folks that are legitimately making an effort at it to get that classification.
I think this gets us back to some of our early conversations, in that one of the things that we, prioritized here was how can we incentivize agricultural production in the state of Montana. And I think if we don't necessarily try to use the hammer on people, but to delineate where we can incentivize, maybe we'll get two birds with one shot, in that we can eliminate having to prove out what we're doing on our tracts of land, and also to be generating more agricultural product in the state of Montana. So I think that if we talk about eliminating non-qual, well, the flip side of that could be promoting ag production.
All right, great discussion. About 11:25, I think that clock got changed. And our next presentation is another member of TPR, Aaron May, who's going to provide a discussion about Schedule F. Aaron?
Good afternoon, everybody. Good morning still. For the record, I'm Aaron McNay. I'm with Tax Policy and Research. I'm going to talk a little bit today about Schedule F. Real easy, real quick definition. What is a Schedule F? Well, the Schedule F is just a form that taxpayers who have to file a 1040, a 1041, or a 1065 fill out so that they can estimate their farm income expenses. So pretty simple stuff, right? As with both things with taxes, it's a little bit more complicated when we actually get into the details of what all of that means. So the first part of my description there is it's a form that people who file a 1040, 1041, and 1065 use. Well, who files those forms? Looking to the IRS, here's what they say. They say that people who file Schedule F are individuals, trusts, partnerships, S corporations, LLCs, taxed as partnerships, and sole members of a domestic LLC engaged in a business of farming to report farm income on Schedule F. So if you are a sole proprietorship, if you're a LLC with a sole member, you're going to be filing your 1040. When you file your 1040, you're going to be also filling out and filing your Schedule F. On the other hand, if you're an LLC structured as a partnership or some type of other pass-through entity, you're going to be filing Schedule F and file your partnership, your pass-through return. And then finally, if you're a trust, you're going to be filing the Schedule F when you file your trust return. So those are the people that generally are going to file the Schedule F when they're filing their returns. So if you're an S corporation, a pass-through, trust, any type of those organizations, those are the people that are going to file the Schedule F.
Aaron, but if you're a C corp, you don't file an F?
Yeah, I was going, we can address that now, right now. You're absolutely right. If you are a Schedule C corporation, you will not be filing a Schedule F. Instead, C corporations, they use Form 1120 to file. So yeah, if you are a C corporation, you would not be filing a Schedule F, even if you are engaged in farming activity, generated farming.
What about a 501c3? Would they file a Schedule F? You're typically filing a Form 990.
Yeah, that's a good question. I don't know for sure. I would have to look into those particular organizations. But I can look into that. So that's just a quick overview, and then exactly how you file, how you're going to report that income. Again, differs depending on how you're structured. Again, if you're a sole proprietorship, or if you're a single member LLC, again, you're going to be reporting that farm income on your 1040 for your Form 2 or Form 10 income tax. On the other hand, if you are structured as a partnership, the partnership will pass through their income to you, and then you would be reporting that income as partnership income. So that's who's going to file. And so then the other part of that statement was people report their farm income and expenses. So what qualifies as farm income? Again, we can look back to the IRS. How do they define it? They define it as income from farming reported on Schedule F includes amount received from cultivating, operating, or managing a farm for gain or profit, either as an owner or a tenant. So again, the important thing here is you're getting income from farming activity. So you don't necessarily have to own the land. If you are a tenant and you're generating farming income, then you would use your reported Schedule F. And also at the same time, if you have agriculture land, but you are not engaging in farming activity, you aren't generating farming income, then you wouldn't be filing Schedule F, because again, the Schedule F is for reporting farming income. So this, again, the IRS.
One question. So to Chuck's note about 501c3 is organized for not-for-profit. Right? So this definition over here, I guess we'll research that, but I would guess in that definition it says for profit or gain. So 501c3 by definition is not-profit. We'll find that out for sure.
Everyone.
Yeah, we'll verify.
So then they continue on and defining what farm income specifically means. So it also includes operating stock, dairy, poultry, fish, fruit, or truck farm. You can generate income from plantation, ranch range, orchard, grove, and it includes the operating of nursery, which specializes in growing hormones. So a lot of these farming activities, but they are specifically clear that it does not include anything like gains or losses from the sale of the farm assets, such as land, depreciable farm equipment, buildings, structures, or livestock held for breeding or for dairy purposes.
So if I own the property and it's qualified as ag land, but I lease it, the income I generate from the lease is not reported on a Schedule F, correct?
As long as you are not materially involved in the farming activities, as if you're just leasing out the land, then
so I would still have property tax liability. Somehow I would have to demonstrate that the property is used for agricultural production. Yeah. Okay.
If you have a tenant, your passive income, you pay income taxes on that, but you don't have farm income. But that still doesn't mean that the farm isn't whole, because you have a tenant with farm or ranch. So that's
it does point to the ability to automatically somehow on an annual basis ensure that they're still operating it as a farm. Wouldn't work in your example because you're the owner, but you're not reporting any income on Schedule. We have to find a different way to be able to automatically verify that through income tax.
That's kind of the purpose of this discussion, is a Schedule F, a tool that you can use to differentiate when you get done to figure that out.
So yeah, and we've kind of already addressed on that, kind of bringing out this question, really, are there reasons why property owners do not file a Schedule F? We've kind of already addressed both of these. Again, we're talking about the income tax here, so we're talking about income. If you own agricultural land, but you aren't generating income from farming activities, you would not be filing a Schedule F. And then, as Scott mentioned, if you are a C corporation, they do not file a Schedule F. They have their own separate. So yes, it is quite possible for someone to own agricultural land, but not be filing a Schedule F. And there are more esoteric reasons, other reasons why someone might not, but there are absolutely that would be the case. One of the questions that we've received is the department received information on Schedule F, and the answer is that yes, we get that information from 2 different sources. One, when taxpayers file their Form 2, they provide us also with their Schedule F. So we do have the actual Schedule F, and then also on the 1040 and on Montana's Form 2, taxpayers report on Form 2, line 6. They report their net income that they receive from farming activities are on their regular income tax forms. So we have this information from 2 different sources. We kind of have a summary on our Form 2, but then we also get more detailed information on the Schedule F. Now, it's important to note that if someone files their Montana income tax return in, say, a paper form, yes, we might get their Schedule F, but that doesn't get loaded into our digital tax system. So we don't have that information necessarily unless we went through a process of those paper returns. We do receive the Form 2s in a kind of digital form through our file system. So if you file electronically, we do have that in our tax processing software. So we do have that information that we can look at, but it's not a complete set of records.
Will this still be true with the new revised tax code under Senate Bill 399 that Hertz passed in 2021?
That's a very good question. So when it comes to Montana's Form 2, starting tax year 2024, taxpayers will not be reporting their various income sources. So we won't necessarily have it on our Form 2. However, again, if you file through the modernized e-file system, we file digitally, we will still be getting copies of your 1040 and your Schedule F. So we won't have necessarily the complete record that we have on the Form 2s now, but we will still be getting some type of information out there. Again, it just may not be a complete record of all taxpayers.
Thank you.
Do you have a question? I just wondered how hard it would be to change the Montana tax form to just have a box you check. So if you do have passive rental income, check whether or not it was agricultural. I mean, just for information purposes, not to ask it now or anything like that. You don't get $100 a year for a 20-acre parcel. Somebody farming a lot of them there. 800 acre deal.
The question is it possible to do it? Absolutely. Now, as to the ease and feasibility of doing it, that's a separate issue because again, adding fields and stuff like that to our record system and to the form itself, again, potentially it has some involvement work associated.
Would it require a legislative change of any kind though to require that?
I don't believe so. We asked some information on the as means of for our personal records and for identification for that. So I don't necessarily know the reason why we would be unable to ask that question.
What was the question? I couldn't hear.
Oh, I'm sorry. Would it be difficult to add just a box to check on your regular income tax form if you had passive income from a rental from an agriculturally related piece of property, just for data purposes, and then that would be an opportunity to maybe check back through the records to see the ownership, to see if it really did qualify, to see if it was something that needed to be reviewed. That was my question. At least you have a trail about it. Yeah.
Talking about the records and information you have, I went in and looked at the information reported on Form 2 and on our digital Schedule F information. And so that's kind of what we have here in these tables. This first table here provides a breakdown of the farm income reported on Montana's Form 2. It's for tax years 2014 through 2022. The first kind of columns here, the total households, that's just all full year resident returns that we have received, and then it shows their average federal gross income. And then the second column portion of the table is kind of showing specifically for how households that reported farm income on their Form 2. We can see it ranged between 18,000 and about 16,800 over the past 8 years. This has been about 3 to 4% of all households. On average, they've reported negative income for all the years, ranging between 7,000 and a little less than 20,000. And if we look at the federal adjusted gross income of people reporting farm income to non-farm income, they tend to make a little bit more than the average household in Montana. So that's the table, and then the following charts are just kind of showing that information.
So your households are accumulation of all the taxpayers in that household.
So when I say
you're looking at adjusted gross income.
So yeah, for when I'm saying households in Montana, if you are married, you can file separately on the same form. And so what this is, I'm just saying, if you're married, I'm counting you as one instead of saying it's 2 separate returns. So that's what I mean when I'm saying household. So if you're filing joint, that's one household. If you're married, filing separately, I'm still counting it as one household, even though technically you filed 2 returns. So these graphs here are pretty much just the same information in the table that I talked about, but just kind of showing it in graph form. You can see over time, the number of households reporting that farm income has been decreasing slightly. The total amount of farm income reported has decreased from 14 to about 18, but it's kind of leveled off since then. The same with the average farm income reported. And then finally, the last kind of graph here is kind of comparing, like I said, federal adjusted gross income for all households versus those that are for farm income. So again, the federal adjusted gross income of people reporting farm income tends to be a little bit higher than household as a whole, with that increasing in the last 4 years. So that's the information that I gleaned from our Form 2. And then I looked at what we have in our Schedule F information. This provides a little bit more detail, which is the nice thing about it. The only problem is again, it's not a complete record, but you can still look at it for a couple of years. We see that about 80% of Schedule F information has Social Security numbers reported, so probably those are more the sole proprietor, single owners, while about 20% reported using FEIN, Federal Employer Identification Numbers. So those are probably closer to formed by partnerships. And the Social Security number group, they report about $500 million in income losses, with the FEIN group reported about $250 million in income losses. When you file your Schedule F, you report your industry, kind of what your activities are. Using that information, we looked at that to try to provide a breakdown. About 1,000 of the Schedule Fs, they didn't report any activity or business, so we don't know for sure what they're doing. But we could see that we had crop production, animal production, forestry and logging. About The largest group was the animal production. There's about 15,000 Schedule Fs reported for animal production, while there's about 7,500, 8,000 for crop production, then finally about 250 for forestry along. I did provide a little bit more detail on the last chart there. Again, it's based on what they report. They get into more detail right on your Schedule F. My concern is just that it's quite possible that one year they were reporting something, but then they just wrote it a little bit differently the next year and it got shifted around. But at least this is a breakdown kind of if you want to go a little more, just might be a little bit more fuzzy in terms of the numbers. So just a quick overview, Schedule F information. Want a discussion, questions, or anything like that, but that's all that I have prepared.
So on the lease rental portion, if they're leasing their land, they should be filing a Schedule E. So like the fee modernization, you have those same numbers, but I think on that Schedule E, there is no detailed information whether it is leasing grazing land versus they have a rental property in town. And I believe it's all lumped together. So if you had 160 acres that you were leasing out and had a rental property in town, you're just reporting your total income from all your rental properties. I don't believe there's a detailed breakdown on that Schedule E. So they should be filing the Schedule E. It's just not very helpful because I don't think we would be able to differentiate what that rental income is actually derived from. Yeah, it does.
We have a question online.
Yeah, I have a question. So for out-of-state residents that have a farm in Montana, they would still have to file a Montana return and have a Schedule F for their farm?
So yes, absolutely. If the farm is in Montana, that's Montana source farm income. So those taxpayers would have to file a return either as a non-resident return or if they moved here partially as a return. They would absolutely have to file a Montana return, report that farm income, and then also file a Schedule F as well.
Right.
And in fact, when I was looking through the numbers, part of the reason, if you look, when we look at the Schedule F versus the Form 2 information that I was providing you, the Form 2 information is lower than the Schedule F, and that's partially due to I was only reporting 4-year resident returns. When I looked, there was definitely non-resident returns that had reported farm income. So that's part of the discrepancy there, is that there absolutely are non-residents that report that in there.
Okay, thank you.
I've got a question. Could I have you guess approximately how many people that have ag property? So those ag property taxpayers, how many of those do you think are filing a Schedule F? What percentage? I guess what I'm asking is what's the overlap between the two?
I hesitate to guess just because I haven't delved into the C corporation information. I could look and see how many C corporations are reporting being in the agriculture industry, and that would potentially give us a little bit better idea as to kind of the Schedule F versus say Schedule C information. I'd be willing to look at that and suggest some of that, writing that. But until I do, I'm hesitant to say for sure.
A lot of those out-of-state people might, they're reporting income, rental income, but they're not filing Schedule F because they're not active participants. Or, they still own the land, but they moved to Arizona or down to Florida.
Right,
or it's been inherited by their kids who live out of state. I think the Schedule F thing is probably, and gonna be more trouble in the court that uses an identifier of who's that owns by agricultural property owner in Montana, but I don't know.
Right, I mean, again, that came back to our earlier discussion of between, are you getting farm income versus rental income? So yeah, if you own a farm, again, if you're, I guess, not doing any farming, not getting any farming income, you would still, again, have to report that as Montana source income, but right, would you be reporting it as rental income versus?
The point of this working group is to try to figure out a way to identify who should get the preferential agricultural treatment. I don't think there's anybody in the room wants to say, well, because you retired and moved to Arizona, you don't get treatment on your land, they were renting out to the neighbor to farm.
All right. Karen, other thoughts or discussion? Looks like lunch is just about here, right, Crystal?
It's ready.
So how long would you like to break for lunch?
We have one question online.
I'm sorry, go ahead.
Sorry, I just had one more question. Is a Schedule F the only indicator that the Department of Revenue can use to determine the farm income? I think they can use other, or if it's in question, they can ask to see receipts of sales or something. The point being is that it's not hard for someone just to write in $1,500 on a Schedule F, and when they got, $30,000 in write-offs of their farm, I mean, the $1,500 is a pittance for them.
There are other ways to verify income. I mean, obviously, we go through and verify people's income that report this information. Now, as to all the means that we use to do that, I'm not privy to that process. So again, I can't say for sure what all those resources are that we have available.
Couldn't you say if you file farm income Schedule F, then you automatically qualify because you have the records? If you don't and you have farm income that's reported somewhere else, you have to verify that in some way. So it's kind of like the onus is on you if you want preferential treatment to show if you don't file Schedule F that you have farm income in some other form of fashion.
It
wouldn't seem like it would be that hard to show if you're getting a preferential tax treatment.
So if you're gonna use the Schedule F, you're gonna capture whatever, a large percentage, but not everybody. So you gotta figure out some other way to figure out what to do with that Bob's example of the others who aren't going to be captured by just identifying their Schedule F.
Yeah, I mean, it seems like, you could use the Schedule F as one of several different criteria that you could use that would be a potential possibility.
Maybe it's as simple as you just have to attest that the income was derived from the lease of agricultural or productive agricultural property or something else.
And your Schedule E actually does make you report your income by property. So if I have a fourplex, a standalone house that's rental property or a business or whatever, you have to delineate each one of those separate parcels and describe the income from each one of them. If you're worried about the rental income. Option tool.
Other questions, comments? What's for lunch, Robin?
Sunset is for lunch today.
All right. So is a half an hour enough, or would you like a little bit longer? Okay, so let's do a half an hour, so about 12:30, 12:35. You can be in the bathrooms or right next door.